Have you seen it, counsel?
Yes, Your Honor, I have seen it.
She's positive for cocaine.
Right. Your Honor, when the bond was set, I wasn't actually present when the bond was set, but at that point, I think they all agreed that her major problem was that alcohol. That was why she entered a recovery program through community corrections. And she's also been attending AA. Now, she's not been positive for, as I understand it, she's not been positive for alcohol use since that time. This cocaine use is kind of, I don't know, an anomaly. And it seems from my discussion with my client, it's kind of situational, and she realizes that this is absolutely unacceptable.
She had another anomaly back in March.
Right, I understand. But what I mean is, it's not, unlike the alcohol, it was not the dominant problem. Yet it is a problem, of course, but it stems, I'm told, from a friendship that she has with somebody that she's had for many, many years. And apparently this other person got into cocaine use, and she would sometimes participate when she was with that person. She realizes she has to break off all contact with this friend because it's apparently evolved into a relationship in which cocaine is customarily used. So we would ask, of course, that bond be continued, and if court thought it was appropriate, she could be put on a tether. She has been going to, she had 8 weeks of first phase recovery program, and she'd started the second phase prior to this cocaine use. And she also has been going to AA once a week in addition. So the recovery program, I guess I would have to say, has been partially successful. And we would like to have an opportunity for her to continue to work on her recovery through that. And I know Mr. Kennedy and I have talked about possibility of resolving the case through recovery court, but he's not sure that she's eligible. And I've been waiting to find out if that's true, because that might very well be a good resolution. So, and in the meantime, I mean, she is the caregiver for three minor children, ages 35. They're all her children. And her significant other with whom she lives, he works full time for one of the car companies. I forget which. For Ford. And is gone in the daytime. So caring for the children, especially when school gets out, which will be pretty soon now, would be very difficult without her presence. But so of course, we're asking for bond to be continued or possibly be modified to provide for her to have an alcohol drug tether. I might also say, I think my understanding is that she entered the recovery program voluntarily. That was not a bond condition. Is that correct?
It wasn't.
She says it was not. So she's attempting to do recovery on her own, but of course, community corrections made it possible for her.
Violation with cocaine.
I'm sorry?
This is her third violation with cocaine.
Apparently so.
Yeah, that's a problem.
It is a problem, but I think a tether would definitely take care of that problem.
I don't have it, of course, but it reads cocaine.
Well, that's what I wasn't sure when she suggested it, whether that was feasible. She seemed to think it was, but I don't know.
She who?
My client.
Of course. She's going to tell you that, and then she's going to go out and use cocaine.
Well, maybe she just doesn't know. I didn't know.
She does what drug addicts do, and they tell you something that's not true.
Well, I don't know that she's truly an addict because her use has not been that frequent. But at any rate, I totally agree with the court that she can't be using cocaine, and I think she also agrees, and she understands.
At what point did that dawn on her?
I'm sorry?
At what point did that dawn on her? When we ordered that she couldn't use illegal drugs? In January when she tested positive? In March when she tested positive? Or this time when she tested positive? Which point did she all of a sudden figure out she can't use it?
Well, she should have figured it out beforehand, Your Honor. but she now tells me she has figured it out, I guess you could say.
I always hate asking, but I'll ask. Why not? I'll bite. What this time made her figure it out?
Well, maybe she's come to a realization that it's not a good thing for her. I mean, she's brought it up in the group sessions that she's had, these weekly group sessions, and I think they've convinced her that she has to cease her friendship with her old friend, because obviously it's not a friendship that's furthering her best interests. And she tells me that she's going to do that. So I hope that she has come to a realization of how damaging to herself that this is.
I'm going to adjourn the probable cause conference in this case to June 5th, 2025, 9 a.m. Because of her violation, defendant's bond is revoked, defendant is remanded.
Thank you, Your Honor. That's it for me today, Your Honor.
Thank you.
Yeah.
Happy birthday.
Thank you, sir.
On the record is the people versus Carlos Lorenzo Durham. 4, count 1. Only count 1. Police officer resisting and obstructing. This is a habitual offender court offense notice, and also case number versus Carlos Durham. Mr. Durham is charged on this case with count 1, weapons, firearms, possession by a felon. Count 2, weapons, felony firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, felony firearm. Count 5, carrying concealed. Count 6, police officer assaulting, resisting, and or obstructing. And this is a habitual offender fourth offense notice. And Mr. Durham, can you state your full name for the record, please?
Carlos Durham.
Okay, so I'm still going to keep it the same, Attorney Taylor Coleman, because of the cases on both cases. I am going to wait until we get to the probable cause conference on the 25th with the DSU report to determine whether or not I'm inclined to reduce the charge. I need him to show the court for something, because we're back at the probable cause conference. I want you to listen up very carefully. Your next court date is January 25th. That is a Wednesday at 8:30 a.m. Can you hear me?
Yes, ma'am.
Okay, so you'll be zooming in from the county jail, and you'll have an attorney present to discuss with you any matters before we go on the record, okay? So show up for that, or you have to show up for that. Then your attorney then can possibly discuss something once we have a DSU report, okay? All right, you all both have a good one. Gentleman from the county jail who just sat down about 5 minutes ago, can you state your name for the record, please?
My name?
Yes, your name.
My name is Carlos Lorenzo, and I'm here to represent the person you got on that paper, which is an all capital name, all capital letters. That's a corporation, and I'm not claiming to be him, but I'm here to represent him. An all capital name is all corporation. I'm not a corporation. I'm not dead. I'm not a fictitious entity. So I'm not claiming to be whoever name you have on that paper, which is probably in all capital letters. That's not my name. It's two names in this court that sound exactly alike, and only one of them is mine. What name is on that paper y'all have over there? Is it in all capital letters? That's not my name. But it's my property. It's my trade name, and I own it. And I need to know if anybody has permission to use it from me. So do we have that understood? I am not a U.S. citizen, and I'm not a citizen of the United States. I am not that person on that paper, because that person is a fictitious entity. I am actually flesh and blood. I am a man standing on the land, and that's what I got you. Do you understand that? I'm not him. I'm claiming not to be him.
I just wanted to know who you were. Thank you. I had to check there. Frank Simon, thank you. Richard, you want to speak to your client in private before we go on the record? Because he's still talking.
Sorry, Judge. Can you repeat that, please?
Do you want to speak to your client in private for a moment? Because he hasn't stopped talking for the last 10 minutes. He's still talking. He doesn't know he's on mute, but he's been talking.
I just saw him Monday at the jail, but okay.
Okay, because I don't think we can have his hearing unless he understands we all can't talk at the same time.
All right, I'll do a breakout.
If you're on the record, this is people versus Carlos Lorenzo Durham. Mr. Durham is charged with 1 count of police officer assaulting, resisting, and obstructing. This is a habitual offender fourth offense notice. Also, case 2258771, people versus Carlos Lorenzo Durham. Mr. Durham is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, starting firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, felony firearm. Count 5, carrying concealed. Count 6, police officer assaulting, resisting, and obstructing. This is a habitual offender. Fourth offense notice. Today's the day set for a probable cause conference. Appearances.
Alexander Kirker on behalf of the people.
Good morning, Your Honor. Jonathan Simon, to both matters.
And Mr. Durham, can you state your name, please?
Objection, I'm not a mister. I just told you that it's 2 names that sound exactly alike and only one of them is mine. My name's never been spelled in all capital letters, so that is not my name. Whatever name you have on that paper is a corporation and it does not exist. That's not who I am. I'm not.
What is your name,
I'm here to
sir?
represent him.
What is your name?
My name is Carlos. That's what I go by.
State your name, please.
Objection. My name is not Mr. and I never spelled it in all capital letters. I keep explaining that to y'all, but y'all insist I'm that dead entity on that piece of paper, and I'm not.
What is your last name?
What is your name, ma'am? Can I have your name and your oath of office, please? Did you take an oath to uphold the Constitution, ma'am? Or did you take an oath to violate my constitutional rights in conspiracy with the prosecutor and the Detroit police?
Attorney Simon, what I'm getting here is that Mr. Durham is not present.
Objection, I'm not a Mr.
I can enter a capias because that's not Mr. Durham. Or
Judge, maybe we could have a competency referral.
he knows what he's doing. All right, you all both have a good
Are looking for another episode that has all the boring stuff cut out and gives you just the good stuff, then hear a couple that may interest you. Enjoy